In this resource, we'll examine the issues that may arise from the payment of earnest money deposits prior to closing a residential real estate transaction. The questions raised in this video are of special concern to real estate purchasers. Consequently, they are posed from the standpoint of the purchaser. So, who exactly can hold earnest money? Any person or entity agreeable to you and the seller, but usually a licensed real estate brokerage or licensed attorney. As a buyer, be aware that if you allow earnest money to be held and deposited by a seller or by a builder or developer for use in construction, you risk that they will not be able to return it to you in the event the transaction does not close. For example, due to the seller's death, divorce, bankruptcy, judgment liens, etc. Consequently, most buyers prefer to have a real estate broker or attorney hold the earnest money deposit. Since they are licensed by the state and required to deposit the money in a trust or escrow account, this reduces the risk that the monies will be improperly used. Under the NCAR/NCBA Offer to Purchase and Contract Standard Form 2T, who holds the earnest money? The form permits the parties to select who will hold the money. Whenever a licensed real estate firm or agent holds any earnest money, it must be deposited in a trust or escrow account until closing. However, if any addenda are used with the form, check to see whether they conflict with any provisions in the form concerning who will hold the earnest money or other pre-closing deposits. NCAR/NCBA Offer to Purchase and Contract Standard Form 2T is a well-known and widely used form jointly adopted by the North Carolina Bar Association, a voluntary professional association of attorneys, and the NC Realtors, a voluntary professional organization of real estate agents. What if the NCAR/NCBA Offer to Purchase and Contract Standard Form 2T is not used? Many developers, builders, employee relocation services, and lenders' asset managers use their own sales contract forms. Many will require you to make an earnest money deposit or similar deposit, but they may differ from the standard form in how it is to be handled. For example, unlike the NCAR/NCBA Offer to Purchase and Contract Standard Form 2T, which contains inspection and repair provisions, title requirements, and other protections, there may be no provision allowing you to obtain a refund of the earnest money under any circumstances. Therefore, you must read every contract form carefully and consult with your attorney if you have questions.